laurels. Very recently, if I have to tell you, we were ranked as, we got an achiever status in the logistics infrastructure, which means a lot to a state like Karnataka, where we have been trying to inch up there. And that besides, we've also been ranked number 3 in the export preparedness index, the figures that we have currently, and the latest one is about to be released. We're waiting for the scores, but then from a score of 9, Karnataka notched the 3rd position in export performance, and this is the organization that I represent today. So we are the mandated nodal agency for the promotion of international trade from the state of Karnataka. And in future, all of you budding entrepreneurs may get into international trade exports. So we are the right agency with whom you should be engaging with, because we provide a lot of hand-holding facilitation to youngsters, to promising ones, to ones who are already entrenched in, let's say, manufacturing and others, and you want to foray big in the international markets. So we have a lot of takeaways for you from this organization. First of all, a very, very interesting, incisive 6 days export management training program, which I would urge those interested in getting into exports to take to this program 6 days. If you want details, we'll share it with you after this program or maybe offline. So starting from how, the basics, ABC, step by step, how you get into exports, we provide the complete handholding. And that besides, we have been giving a lot of thrust to the Atmanirbhar initiatives and all, like this ODOP, One District One Product Scheme. And then, we have been talking about champion services sector. Then, we've been trying to speak about developing district export hubs. So there are many such initiatives which are happening at this Export Promotion Center. And I'll be happy to share in detail, or probably a detailed session, as we go along. Coming back to today's session on demystifying intellectual property rights, I would like to tell you that oftentimes many people think that IP and me, what is the connection? Because, some people may think, they are not technical. Some may think they are purely management. How does it impact me? But today you'll learn from my dear friend and esteemed speaker, Dr. Farah Deepa, as to how at every step we are actually in and around the IP ecosystem. Whether you call it as a trademark, that is the power of the brand, the logos, that's an IP for you. Whether you talk about academic journals, you're writing papers, research, and all of this, the music that we always download from the net, or the books, the authors, all these come under the copyright spectrum, which is an intellectual property. Similarly, of course, your inventions, both products and processes, patents. You never know, tomorrow you could become an entrepreneur, and you will have to ensure that when you set up shop, you need to watch out that you are not infringing on anyone else's intellectual property or the creation that they already hold. So that is precisely one of the important reasons that everyone must understand the intellectual property tools and how we could leverage it. Many more to say, but then I have been just given 5 minutes time to open this up. So I declare this program open, and I'll be back with you day after tomorrow on an exclusive session on geographical indication tag products, which is a rich legacy of the state, and where we have been doing extremely well in terms of the kind of products that we have in our basket, where each one of us, the young and old alike, can be brand ambassadors and in their own way promote these ancient and traditional legacies of the state. And that is also an intellectual property too. So on that note, let me hand the floor to the next speaker, Dr. Farah Deepa. And thank you once again, Dr. Sarla Devi College, for inviting us to conduct the next 3 days sessions. Thank you so much.
Thank you, Madam, for introducing speech regarding intellectual property right. Now I would like to call our principal, Dr. Manjunath Reddy sir, to speak few words about this program.
Good evening to all. Myself, Dr. H.K. Manjunath Reddy, Principal, Sarala Devi Satish Chandra Agarwal, Government First Aid College, Badari. First of all, I wish to thank all the participants who have joined for this 3 days webinar series on the topic intellectual property rights, particularly with its significance in business innovation, research, and NEP 2020. I hope that this topic would definitely benefit all the participants in this webinar series. I thank Department of Commerce and all the faculty of the Commerce and IQAC cell of our college for organizing such a beautiful program in this occasion. So I wish all the best for all the participants and the organizers for this 3 days webinar series. Thank you.
Thank you, sir, for your motivation words. Now I feel privileged to introduce today's speaker, Dr. Farah Diba. Dr. Farah Diba is an author and consultant. She has worked with the Menstro company as a senior scientist, has a PhD degree from the GB Pant University of Agriculture and Technology, Pantnagar in 1996. She has further specialized in intellectual property protection from Indian Institute of Science, Bangalore in 2005. She has more than 25 years of experience in the field of intellectual property, agriculture, biotechnical industry, research and development, teaching and research guidance, and scientific outreach. Her areas of research includes IP protection, technology prospecting, competitive intelligence, and knowledge management. She has several publications in peer-reviewed journals, including those on BT cotton and BT corn and IPRS. She is an inventor with the patents and genomics. Apart from her scientific publications, she has literally worked to her credit, including 2 English novels, Corporate Career and Rainbow Shadows, and other books. She is also accomplished vocalist. With this brief introduction, I will welcome Dr. Farah Diba Madam once again. So without taking too much time, I would like to invite Dr. Farah Diba Madam to start today's session.
Thank you so much, ma'am. And it's my privilege to be in this meeting, and I hope it will be a good interaction. So I'll put up my slide deck, and please let me know if you can see the deck, and then I'll go ahead. And thank you for the invite. Okay, is my screen visible now? Okay, thank you. Is my voice audible? Because
yes, ma'am.
Oh, all right. So I welcome you all to this evening session, and I hope that we can take questions after the session. I'll just take you through the spectrum and how is it relevant to NEP. And in an academic environment, intellectual property is one of the most important aspects in today's world. So what we are dealing with right now are knowledge economies, and these knowledge intensive economies are shaping a totally new business landscape, because wherever you see, you have knowledge-based companies which are coming up. This is an industrial revolution of the 4th kind, where the frontier technologies are changing the way we do business. And then the fast pace of technology development, as well as data generation, it's not allowing the legal system to catch up. It's developing so fast, the data is being generated so fast that people are still grappling with the technology advancements. And you all know that Internet of Things, artificial intelligence, the 5G mobile revolution, it is all just changing the way we live, the way we study, the way we do research. So it's very important to understand this whole setup and to use it to the advantage. So the National Education Policy came in 2020, and its mandate is to design a culture of innovation. So now an education system has to be holistic and flexible. That means it should be multidisciplinary, and there's a lot of emphasis on vocational education, where you will be having things like artists and carpenters and people who are developing things which are artistic. So it's very important to have the awareness of IP tools, and especially copyrights, industrial designs, and traditional knowledge. We should understand how the setup is, how the ecosystem is, and how we can leverage that. Then there's National Research Foundation, which will catalyze the research. It has the grants that will be given, and it will be a liaison between the researchers and the different bodies of the government as well as industry. And the idea is to get the childhood education so well placed that you have logical thinking, problem solving, and play-based, discovery-based learning. And of course, arts, crafts, music, which is very important for understanding the artistic world, and add to it the information technology, where copyright becomes very, very important. So apart from that, earlier we had the IPR policy, which came and its logo is Creative India, Innovative India. And the cell for IPR promotion from DIPP Government of India, there are a lot of resources that can be used. So all the higher education institutions now have to become innovation hubs. The environment and the ecosystem should handhold innovators and allow them a path to go ahead and do interdisciplinary research. And there should be greater industry and academic linkages. So we should have incubation centers like in the developing countries, starting from the universities. The research areas, of course, depend on what is happening right now. Climate change, population dynamics, biotechnology, healthcare, of course, after the pandemic. Then the ICT related subjects, which are making a big change in the way we do our work. And of course, social sector reforms, social sector research is very, very important for a developing country. Clean drinking water, sanitation, renewable energy, sustainability, all these things are the buzzwords for research, especially in our country where a lot of development needs to happen in these particular sectors. And there will be funding institutions apart from NRF, there will be DST, DBT, ICR, ICMR, and so on. So if we know where to go looking for funds, how to create projects which are relevant, it will be a good focus area. Then in addition to the general education, agricultural education is very important because India is an agrarian economy and it's a biodiversity hub. World over, we are one of the biodiversity hotspots. So agriculture universities, all the allied disciplines, which is food processing and so on. And there's a lot of emphasis in the national IPR policy on traditional knowledge, plant variety protection, plant breeders' rights, biodiversity, and agricultural-based geographical indications. So Prabha will be speaking on the third day on more on GIs, and I would try to just put the subject in place. So these are the mandates given by the national education policy. And in the technical education, of course, engineering and technology, architecture, all these areas are important. And awareness of the IP capture mechanism is the prerequisite for utilizing the whole system which is generated by the government and the industries. And there should be more collaboration between the educational institutions and industry so that we can develop a product and take it to the market. Now, innovation growth, if you have seen over the past 100 years, from the industrial revolution, the engine and transport, biopharma, ICTs, to now digital technologies, all these have come one after the other, and the technology development goes on. So the business of science is driven by these three factors: law, technology, and business, and there'll be interaction between them. So if you have a technology, you should know the strategy to take it to the market. And if you have to do a technology transfer or draw a contract, you have to go to a lawyer and get the techno-legal aspects done. So all these things have to come together in place. Then only from a lab, you can take a product out and take it to the market. Now, intellectual property rights are basically resulting from the creations of the human mind. We have the abstract ability to think and create something new. And it is very essential for entrepreneurs to know how to guide their technologies, not only technologies, but the brands that we do after the technologies are commercialized. So I'll take you through this whole process very quickly, and please keep your questions towards the end and we'll discuss. Another factor is that we should know how's the technical field growing and whether we have the freedom to operate. So if you know the technicalities and who's doing what, then only you should go ahead and invest your money. And all intellectual property rights are territorial. That means country by country, it is varying. So the purpose is to encourage economic development by rewarding the intellectual creativity which comes from human intellect, and then to benefit the society at large, because we are cultures of origin. We have, say, Ayurveda, which is coming from the society over the last so many thousand years. So those cultures of origin have to be respected. So now let's take a very simple example of Coca-Cola. So the formulation itself is a trade secret. The trademark is the white and red font that you can see, and the how it is designed. The bottle is an industrial design. So for one simple product, which is a beverage, we have so many intellectual property tools protecting it. Now, getting a patent is very, very stringent, tedious, and long drawn. But if you want to register a copyright or a trademark or an industrial design, it's comparatively easier. So you can use all the tools in proper combination for a simple and small product also. So these are the tools. This is the whole toolbox of intellectual property. On one side is industrial property, which is patents, utility models, trademarks, GIs, plant variety protection, and so on. And on the other side is a copyright. So we'll discuss these quickly. Now, these are the laws which are already in place for biodiversity, for GI, for plant variety protection, trademark and patent. And the government organization, the non-government organization, and community-based organizations all come together, especially in biodiversity and protection of plant variety and Farmers' Right Act. So all these things have to come together, and the relevant stakeholders have to get in place to make this work. So whenever we discuss anything throughout this presentation, you should understand what is infringement. That is, somebody is using somebody else's intellectual property without permission. So the person knew that this exists. That means the person had access to the protected IP, and the person created an imitation, which is substantially similar in terms of idea and expression, look and feel. It looks same. So if you go to a court, they will do these tests and see whether it is a legal problem or not. So please keep that in mind as we discuss these cases throughout the presentation. So I'm giving a very simple example of a photograph. The black and white photograph was taken by one person, Roger. Then after some time, he realized that a person has created a sculpture, which is substantially similar to the one you see on the other side of the screen, the black and white one. So anybody can understand that this is a copy of that. It's not an original. It's been copied from the photograph. So the person went to court, and the court said, you have to pay the person whose original work you are quoting. So it's proven that the person had access to the photograph and he created something substantially similar, but it was IP protected. So if you know what are the modalities, you will not do a mistake and be landing up in a legal case. So the idea of creating awareness is this. So now this is a landmark case about if somebody has read this book called The Picture of Dorian Gray by Oscar Wilde. So Oscar Wilde is a well-known author, and his photographs were taken by one person, and other people started misusing it. So this is a case of 1884. So long back, it was decided that photography is also copyrightable. So this is how we have evolved through the years. And whenever there is an intellectual input in a particular work of art or a photograph or a book, there is a copyright there, and that should be respected. So if we know, we will not step on other people's shoes. Similarly, this Yash Raj film versus Sri Ganesh production. So that Band Baja Barat, the theme, concept, plot, character sketch, story, script, everything was copied, blatantly copied. So they went to the court. This is another example where Tigerton Bridge, the band, they said that our music template was completely taken. Even the sequence was taken. So this is going on, the case is still going on. And you can go and just listen to both the soundtracks and see whether it is really similar, because courts take a long time. So this is the latest thing that Facebook changed to Meta. And you have seen this new logo. So it completely lacks creativity, originality. And if we are IP aware, we will not get into legal hassles. So if you see the sign, it's an infinity sign, which has been used by various organizations, and it's overused. So whatever is overused will not have clear identity. So that there's a problem, there'll be a legal problem. So we should avoid that. So if we know what is an intellectual property, we will not do these mistakes and land up in legal trouble. So the first most important and most heard about IPR is patents. So patents are exclusive rights, and they're granted on the basis of novelty. There should be something new, innovative. That means an intellectual step forward, an inventive step is there, which is above and beyond what is existing. And it is industrial application is there. So there's a utility, it's useful. So these are the three criteria. And of all the IPRs, Patents are the most strongest and they have a term of 20 years. So what is a patentable invention? You cannot just patent everything. Whatever is patentable will go through the process and get a patent. So any new product or an art or a process of manufacture, a machine, a substance produced, a drug, a compound, like that. So any new or useful improvement in an existing technology. So you have so many years of technology development, you add something new to it, that is innovation. So people often get confused. So how do you create an inventive step? That's very important. So you find the closest inventions, compare and determine distinctive feature of the new invention that you want to create, and create features that are solutions to a problem. So that's called a problem solution approach. So you will know where to put your money. So the process for solving problems is basically the design thinking framework. It's a human-centered approach. You should have empathy with the person who's going to use it. And this is useful for products, services, processes, and organization. So you first create a prototype in your mind, then you create an actual prototype, you test it. So there's a lot of ideation, a lot of iteration which happens. This is the system of designing new products. So there's a creative flow from a theory where you think that this is the idea to creating a prototype, which is a design, to creating a product which will be continuously improved based on the customer feedback. So let me clarify this. So the first bicycle looked like this, but over the years, there have been several small inventive steps added to it that we arrive at a bicycle like this, which is a racing bike. So invention is something you created first, and then you went on innovating step by step. And so many people contributed, and you get a better product, and the society is benefited. So the whole innovation cycle depends on the consumer requirement, problem solution, basically. What is the problem? What is the solution in a particular product? How's the market dynamics, and the technologies available, because the technologies parallelly grow and new things come out. So you can just go ahead and use them. So for example, Apple is a cell phone company. They do the products, but they needed something which covers their phone very well and which is very strong. So they did not invent Gorilla Glass. They just took it from Corning. They just prospected who has a technology and they licensed it. So that's another way of, in a multi-component technology, you can just license it from another person. That's the right way of doing it. So if you know these nuances, you can go ahead in this particular logical manner. Now, this is a very simple example of a tomato sauce, which used to come in a bottle, a glass bottle, and it was very difficult to handle it. So somebody known Paul Brown, he created this bottle, which is upside down, which has a good grip, which is a plastic bottle, and it has a valve. That valve he created after hundreds of iterations, and he patented that valve. So once you store the bottle upside down, you will get all the sauce out. So it's a very simple solution to a very simple problem. But then he licensed it to all the companies which produce tomato sauce or whatever sauce. So this is how to go about it. You create something which has broad use and you can license it to other people or you can sell it. So like any other property, IP can be sold. So the second very important IP is copyright. So it is any original work of authorship fixed in a tangible medium of expression. That means you had an idea, you made a movie, or you wrote a book, or you wrote a journal or whatever article. So any work of fine art, broadcast, the TV and internet broadcast, computer programs and databases in India also come under copyright protection because patents are conditional, case by case. So if you are aware, we know that copyright is also for IT related, software related inventions. So it's a bundle of rights. So you can have the right of reproduction. You can create as many copies. You can communicate to the public. You can adapt it into a movie. So if you've written a book, you can adapt it into a movie. You can allow people to translate. So you would have seen R.K. Narayan's book, The Guide. It was made into a movie. Or Da Vinci Code was made into a movie. So in the middle is one of my novels. So you can write in one form and then it can be transferred the movie rights can be transferred to somebody who will make it and pay the author money and credit. So it's very important to cite who did what. And computer software related inventions, basically because the source code is in a text format, but it works with an engineering system. So in India, hardware is patentable, components are patentable, but software has to be protected by copyright because it's difficult to prove that it is a invention, a patentable invention as such. So there are rules and steps for that, legal steps and tests for that. So any patent examiner will take it through a 3-stage test. And if the contribution lies only in a mathematical method or a business method or algorithm, they will not give you patent. They'll ask you to write the source code and take a copyright. But when the software is in conjunction with the hardware, then only it will be proceeding to the patentability criteria and then going on to the test. So it's important to understand, if you cannot have patent, you can take a copyright and protect your invention if it's a software. Again, the copyright notice, the first thing you do if you have a copyrightable work, you have to put a notice on it even before going to the registrar office for registering the copyright. So for example, corporate copyright 2011, the year of publication, name of the author, all rights reserved. So what are the rights? Right to adaptation, creating multiple copies, and so on and so forth. And if you have an ebook, that also has an ISBN, it has ASIN. So like that, you can protect. So what is infringement? So infringement is that you have an assignment, you copy and paste from the internet and you present it, it will be thrown in the dustbin because internet is a great source of information, but you cannot just blatantly copy and paste something because it will be considered infringement and plagiarism. So we should understand, especially in an academic environment, what is copyright, what is plagiarism, and what is infringement. So infringement is basically use of somebody else's protected work, which is copyright protected, without permission. So the person who has a copyright has the exclusive rights to reproduce, distribute, display, adapt, so on and so forth. But if you do not give citation, it's considered as academic dishonesty. And if you are using somebody's material, you have to give citation, you have to give the credit which is due. So for example, you are doing an assignment or writing a research paper. So there's a proper methodology, scientific methodology, which is called the research methodology. So first your student or your research scholar, you will be saying, go review the literature. So the research scholar will gather all the information. Then you will work on a hypothesis. You will get the data tested and analyzed. Once you interpret the data, what will you do? You will publish a paper on that. So when you are publishing, you have to keep all the references and cite them in the list of references. If you don't do that, it will be considered plagiarism. And there are rules for that we can discuss. So basically, if you do not follow the given standards, there's a zero tolerance policy from UGC, and there are strict punishments, and it will be considered as academic misconduct. So please be aware, especially people in the academics who are doing research or who are having students doing PhDs, please be aware of this, and we can discuss this later on in another talk. So basically what we tell our students is that you crunch the data, you get all the data, you quote, you paraphrase what you want to say, write it in your own words, summarize it in your own words, and then you create submit your assignment or dissertation or thesis. So this is a huge topic. We can talk about it another day. So let me take a case. So in Delhi University, some people were compiling photocopies of different portions from different books. And the photocopy person was creating a course pack and giving it to the students. Some people went to the court. So the court said that it does not constitute infringement of copyright because it's only for educational purposes. And the authors also said, it's okay if the students are using our work, we exempt them. So again, there are a couple of things. One is your right, the other is fair use. So whether it is fair to use it, there are rules for that. That if it's for education instruction and non-commercial, then it is okay. So if we are aware of these things, we will not get into legal trouble. So basically exemptions are not are given that for the purpose of research, for criticism or review, writing a review, reporting current events like journalists do, or in a judicial proceeding if it's used, performance of your work in an amateur club where there is a non-paying audience. So please understand that. If you have a paying audience, then you have to share the profit. If it's a non-paying audience, it's non-commercial. Again, making the sound recordings under certain conditions will be exempt for public good. So those rules are also there. But it's very important to understand what is an open source and what is closed source. So open source ones are the Androids that you have in your phones, the Linux and so on. The closed source are the Apple software, the iOS and so on. So for that, you have to pay heavily. For Android, all the Android phones are, of course, less expensive than the proprietary ones. So plant variety protection is very relevant for our country because we have farmers who are involved in this, and any new variety which is developed by a plant breeder, a professional plant breeder, can be taken under PVP. And if a variety is developed by a farmer also, it can be under the scope of this law. Then we have IC layout designs. So it's a simpler form of IP which is required for IC layout design. Then industrial designs are all over all the products that we use. So basically, it deals with the aesthetic aspect of an article, the shape of a bottle, a pattern, and ornamentation, so on. So anything which is produced under industrial conditions, mass produced, industrial design is applicable for that. And the idea is that other people again cannot make copies of it because we are dealing with a commercial market condition where the customer can be cheated by imitations. So these are the examples of industrial design which we often see, and they're pretty attractive. But when we go to the shop, we are also consumers. So how do you make a shopping decision? Why do you prefer certain brands? And what are the factors that you will take into consideration before putting your money into something? So the brand, the design, and everything, they are very created attractively, and there's an understanding of social, commercial, and aesthetic attitudes of a particular society, a particular group of people who are going to use that. So there's a lot of research going into it. So basically, it's the creating value and identity through brand, which is an IP, which is a trademark. So it's basically a sign or a visual symbol that you will distinguish your product from other people. So there'll be trademarks and service marks and so on. So we are all aware of them because we are users. And you see the airways, there are services, and there are products which are computers and bottles and food stuff, which are products or goods. So brand has power because a lot of investment goes into it. A lot of logic and psychological work goes into it. That's how we design the logos, which the public will perceive positively. And there'll be taglines that people talk about. And it's an intangible asset. It has a lot of value, and people have brand loyalty because the customer uses his discretion. The purpose is to create something which the public will perceive in a positive manner, and they will develop trust over, and they will have a goodwill. So it should be graphically represented. It can be invented name or device or symbol. It can even be a sound mark. So the Airtel signature tune or the MGM, the roaring lion, all those are sound marks. So these are very important, and it plays with the mentality of the psychology of the consumer. So the more fanciful and distinctive the mark is, the more there'll be recall at the point of sale. And if some things are not distinctive, it will become generic. For example, Post-it or Band-Aid or Jeep, these have become generics because they have been overused, or Surf for any detergent. So you should be very diligent with creating a trademark and then maintaining it. So this is an example of Audi, how the trademark itself developed. There's a history. Kindly mute whosoever is making sound. Please mute your mics. Siddhangi Ananda, please mute your mic. Okay. Please request the person to mute the mic. Yeah, thank you. All right. So these are multi-million euro brands, Lifebuoy and Lux and Lipton. So these we come across very often. These are Unilever brands. So multinational companies have multi-million dollar brands, and they are mass produced and mass sold in different geographies. So these are very important trademarks, and the way they are packaged. The moment you see the trademark, you will know where it is coming from, or the trade name, McDonald's, for example. So the two golden arches, it has become a cultural icon. So the way you market, the way you present your work to the your product to the consumer, it makes a lot of difference. So this Cadbury shade of purple cannot be used by anybody else. So specific. So it's called a trade dress. The way the product is packaged, and the catchy taglines, because you're worth it, from L'Oreal and Let's Go Places and so on and so forth. So these are very important things that people will recall at the point of sale and buying. And brands are very important because it's a commercial prospect. So they will develop brand valuation based on total cost, market value, and the future net income. So these are the criteria, and these are the most valuable brands in the world right now. And if you take the example of Apple, they have high reputation, quality, stylish design, and they charge a premium. So if you create a product which is worth it, it has created value for the customer, the customer is ready to pay some extra amount for that exclusivity. So if you see the design of the Apple Store, that itself is a design patent. So it's a glass cube. Anywhere in the world, they have a glass cube design, and there's a glass staircase inside. So this is the height of branding. So now everybody knows what is champagne. It's a bubbly white, sparkling white wine, but it's basically a region in France. So the Champagne region grows grapes, which are white. And then from that, the traditional knowledge and geographical indications are clear. So these are based on the community. So till now we have discussed about individual rights, but now let's discuss about biodiversity, natural resources, traditional knowledge, even traditional cultural expressions. These are all community-based IPRs, which are critical to the livelihoods of communities. And we should know about it, and we should be custodians of that. So geographical indications is basically a notice which is given to a product which originates in a given geographical area, and it has clear history and reputation associated with it. So it will be protected by a register. So there are methods by which GI will be tested and then allowed to be registered, and the groups and communities will be associated with it. And Prabha will talk about it on her talk. So this is how you will register the GIs, and people get the registration certificate. So one of the greatest success stories of GIs in India is Darjeeling tea, which is protected in various geographies, and it's a high premium product. Apart from that, Scotch whiskey, the South African wines, Idaho potatoes, Nanjangud banana, and Guntur chilies, Malabar black pepper, all these are GIs. They talk about a geography, and they have a history and a reputation. There are communities associated with the production, and they come from a particular geographical area. In the center, you can see the GIO India design on the top center. These are cheeses. These are world famous cheeses, and there are huge trade wars fought over cheese. Who owns what? The Parmigiano Reggiano from Italy, the feta cheese from Greek. These are huge, valuable products in the world market. These are our products. These are coffees of India, Monsoon Malabar. And the last one is trade secrets. As I told about Coca-Cola, the formulation is a trade secret. So any confidential information which you can keep confidential is an IP, but it is not declared in any public forum. It has inherent value till you can keep it secret. So the KFC formula or the Big Mac sauce, these are all trade secrets. So let me take one example, which is being discussed a lot in our situation right now. So this is a painting, a recent entrance to paradise, it says, and it is created by an AI system, which is known as DABUS. It is created by Imagination Engines, a company which is based in St. Louis, US, and it is created by a computer system which is able to design something. So it's called DABUS. So when applications were filed in which the AI system was an inventor, it was rejected in UK, US, and Europe. But next year, it was named as inventor in 2 other geographies. As you know, IPRs are territorial. So basically, it was a design which was created by the AI system of food containers. And there's a fractal design. And when the containers are moved by transport, they will stick together because of the design. And they will not spill. So when they filed the application, the patent application, the European Patent Office said that lacks novelty because some other company from Germany had created similar things. So later on, they revealed that one of the inventors is an AI system, which is DABUS. So then they said, no, we cannot allow an AI system to be an inventor in this. Basically, if you want any protection of a IP, the product should be original and there should be a human author. If there is an AI system which is taking the decisions without human intervention, so again, we are on the gray area. So we are on the edge of the technology, cutting edge of technology, and there are gray areas legally, how to deal with that. So WIPO is now dealing with that and trying to put down guidelines, what is patentable, how we can proceed about it. And the dialogue is on. So there are a lot of practical difficulties, and the IP regulators have to keep pace with it and create novel guidelines because the technology is developing so fast. So whenever you want to understand a system holistically, for example, if you want to create IPs, you should understand that from the research to assessment to IP filing, creating a portfolio around one particular technology, the innovation cycle goes on. But then we don't stop there. Then we have to take the product to the market. So you'll do market research. The commercialization requires so many other things, branding and revenue generation, and how the revenue will be pulled back into the R&D cycle. So all these things we have to understand holistically, how to play with the system. And at every step of the pipeline, product pipeline, you will have a provisional patent first, then you will analyze it, whether it should go for an application. A whole team sits and decides. Then you have a patent around one technology, but then you create a whole set of patent, which is called a portfolio. You have 5 to 6 key patents around a particular technology so that people cannot infringe or get into it. That's a strategy. But every technology has a life cycle. So today you have something which is very relevant, but after 5 years, it is totally irrelevant because it's taken over by another technology. So whatever goes up comes down. So we should know where we are in the technology cycle, whether we should put our resources in it or not. So it's very logical that you create something today, you have to sustain it by, you invent it, then you innovate. But then somebody else will come with another technology which will overpower you. So generation 1, 2, 3, 4, we are in 5G now. So these are the market realities, just to put things in perspective. So if you create something, you can develop it, you can test market, and you can take it to the market. But it's good to understand the things in holistically, whether what is your priority, how much resources it's going to take, what are the technologies you want as a core technology in your area of work. So you will continuously review, you will take forward and commercialize, or you will sell it off. So it's very simple. You cannot use it, somebody else may have a use for it. You can sell, you can out-license or outsource. So these are the ways in which you can use an IP. Awareness is most important. If you are in a commercial sphere, you should have business intelligence in place and know who's doing what and where they are. And to be aware, you should go and search because all the data is out there. If you go to these databases, you'll get all the information you require. Use your keywords and do it. And if you create a product, you create a brand, you have a goodwill, you have to sustain it. So this is the example of the Apple computer in 76 versus now. You know how the brand developed, how the product developed, and what market share it contains. Okay. So understand how not to break the law, because if you're aware of the IP rights, you're also aware of how not to get into legal trouble. Be informed, give wherever the citation is due. You can use fair use, use things which are in public domain or use open source material. Please be aware of that. Thank you. Any questions? I'll be happy to take.
So dear participants, if you have any question, you can raise. Otherwise, you can chat in a chat box. I think no question.
Chat box.
Hi, madam. Good evening.
Good evening.
Am I audible?
Yes, yes. Please go ahead.
Very good evening, and thank you for the initiative. I congratulate the organizers. The topic was interesting. Just I want to know, from where I can. Sorry if I skip the topic. From where can I get the copyright? Like, where can I approach? Like, whom should I approach to get a copyright? Or like,
so DIPP has, you have to get it registered through patent office. If you have other IPRs, then copyright can be registered through DIPP, and there are copyright registration officers are there. And otherwise, you have to go to Indian Patent Office, and they have the whole system in place for registering all other IPRs.
it will be like online, right?
Yes, yes. You can just go to IP India website, and you have all the answers there. You can check.
What if, like, just I have a question, because recently I watched a Telugu movie called sorry, I can't recall the name, sorry for that. Like, the thing was like the two different people had the same idea, same thoughts and everything. One person has made a copyright, and other person who didn't made any copyright, but he continued to do it by his own, in his own way.
Okay, so good
So,
question. And let me tell the audience, first thing is to be aware. Second is to actually register your copyright or register your IP, whatever IP you have. If you do not do that, because the rule is the first to file, whosoever files first will get the copyright or patent if it is valid. Okay, so if you do not file, and we call it contamination, if you go and discuss your project with a third person and he goes and files first and you file 2 days later, you will not get the priority. So first thing we tell, if you have something which is worth protecting by an IP, do not reveal. Okay, create documentation. First, you have to create your documentation. So I said, if you have a source code, put a copyright on it. Go to the registrar office, register it. Then only it comes to the public domain. If you come to the, that's what we say, go check the prior art. If it's pre-existing, create something new. If it's IPable, if it's important for you, go and register it first. Do not put it in the public domain. Do not even discuss. Okay. So that's how we have to go about it. And first to file will get the filing. Okay. So priority date is there. If it is second, 2 days or 1 day after that, you will not get the priority. Okay. Yeah. Any other question?
Hello, madam.
Yeah.
Good evening. Madam, I have a doubt. Now we'll get it registered, right?
So somebody has put a question here, how to copyright logo. So copyright is different from logo. Logo is trademark. So again, go to the Indian Patent Office website and register under trademark. Copyright is for books, periodicals, papers, software, and all that. So copyright is applicable for those products or production or recordings. All that will be under copyright. Logo is a trademark. Trademark will be protected under the trademark law. Okay, is it clear?
Sorry for interruption. Just I wanted to know. Again, this is Aditya. Just I wanted to know how long the copyright will be like enforced. Like.
Okay, so copyright is 60 years plus life of the author plus 60 years. So till the author is alive plus 60 years. Okay.
Is there any like exemptions like that? Anything like that?
For each IPR, for patent it is 20 years. For trademark, you can register for 10 years and then renew each 10 years. So for everything, there's a term. Okay, for a video recording or a production, video production, it's 25 years, broadcast production. So there are different lines, timelines given for each of the IPRs. Okay, copyright is life of the author plus 60 years. Then it goes into the public domain. Copyright is a very big topic. I have just touched a little bit on that. We can discuss more, yeah. Okay, any other questions? How to patent for a product. So under copyright, you have to go to the Indian Patent Office and file for a patent. And if it's patentable, you will file and get a patent application, and it will be published in a gadget, and then it goes through the process. It takes about 4 to 5 years. So depending on what product you have. So somebody asked, software will be patent or copyright. So in India, software will be copyright. In other countries, you can have a patent. Yeah. Any other question? Yeah. Who will review the files or publications? So the Copyright Office registrar of the copyrights will review that. Okay. Yeah. Any other question? Okay, if there are no more questions, we can stop here. So you can take it ahead.
Thank you very much, madam. The session was very enlightening about copyright and patent. The session will help all the participants to explore this concept in a better way. Thank you very much, madam, once again. Dear participants, we will share the feedback link in the chat box after the completion of each day's session. It is compulsory to fill the feedback to get a certificate. And every day, new link will be sent to the WhatsApp group to this session. Now, I would like to request Sri Gangadhar, Lecturer, Department of Commerce, SSI Government First Grade College, Autonomous Ballari, to present vote of thanks.
Very good evening to one and all present here. It's my privilege to give a vote of thanks on this occasion. Firstly, I would like to thank today's resource person, Dr. Paraha Deba Madam. Thank you so much, Madam, for your wonderful session. And next, I would like to give a special thanks to our principal, sir. Today is the president of the function, Dr. H.K. Manjunath Reddy, sir. And I would like to give a thanks to Professor Shailaja S.M. Madam, head of the Department of Commerce. And I thanks to program mentor of this webinar, Dr. Prahalad, sir. And I thank to our senior faculty members, Dr. Kanyakumari Madam, Dr. Annapaswamy sir, Sri Gurubasappa sir, and all the teaching and non-teaching fraternity of this institution. Lastly, but not the least, thanks to all the participants to give a wonderful present in this webinar. Thank you one and all. The feedback link has been shared in the chat box. Please fill the feedback form.
Thank you, one and all.
Yes.